'cause you can't, you won't, and you don't stop. Or when you can't, you won't, and you don't stop. Mike D coming rock the show shot.
Having established that, we need to understand the difference between those key terms, which we call conditions, and those lesser terms called warranties, because they have different impacts on our remedies. We now need to think about what actually is a term of the contract and what is not. Okay? So that causes us to look at quite a few different elements. And so why don't we get into that now with the help of a kind of conceptual framework to think about the various statements and documented things that occur when we're negotiating in business. So we can start off by recognizing that not all situations are the same. It can be actually quite easy to identify the terms of the contract. For instance, if you've got a signed written document that both parties have very carefully considered, but a lot of times it's not so clear. So what we need to think about is how we classify various exchanges and statements that occur when we're going to contract. So there are terms of the contract, and they can either be express, that someone said them, or implied, right, where it was an intended term, but it hasn't been clearly expressed. And then there are other statements which are representations that aren't part of the contract. So if you think about it in these terms, what we can see is that there's a series of representations that give rise to no obligation on the parties. In contrast, there are obligations under the contract that are terms of the contract. They can either be express, and express means they're written down or they're verbal, or they could be implied by the court or imposed by statute. So sometimes the courts will imply a term in the contract, and sometimes a statute says a term is in there. For instance, consumer protection guarantees are examples of terms of the contract that are imposed by statute. As you can probably imagine, it's very important to distinguish a representation that's made from a term of the contract. And that's what we'll spend most of our time doing. Where we do look at the terms, we do concentrate on express terms rather than implied terms. Implied terms are quite a technical area of law. I just want you to be aware that they're part of contract law and something you need to be aware of. If you do anything around consumer law and consumer protection, you need to deal specifically with those statutory terms. Consumer guarantees, for instance, we don't deal with them specifically in this course, as it's more traditionally taught in consumer law and we don't have enough time. What we will do, though, is look at what is an express term of the contract. So why don't we get into that to start? So express terms are explicitly agreed by the parties. Often they're in writing, but it can be verbal, which means a contract can be a written document, it can be a statement, or it can be a combination of the two. So we need to understand what we're dealing with in any particular situation. The three key principles we're going to use: the parole evidence rule. Written statement in a signed document is evidence of agreement to that term, and the test for whether a statement is a representation in partially written or verbal contracts. And with these three rules, we can work out most of the time whether something is a term of the contract or a representation. One way to think about the problem is that there's a hierarchy or clarity of obligations. You can go from terms or obligations and rights that are clear and certain through to ones that are unclear and uncertain. So if you have a signed written document, maybe it's been through lawyers, tightly considered, we have clear and certain terms, clear and certain obligations and rights. What about where we've got a written document, right? But it might not have been to a lawyer, and we maybe haven't signed it, etc. And we may also have discussed other things that's not documented. Well, clearly you've gone to some trouble to clarify what you're agreeing with, but it might not be the whole of the agreement, so it becomes less clear. And what about verbal statements? Imagine you're just negotiating and you think you've come to a verbal contract. Well, when all these statements are being made, when we're making all these verbal statements as part of the negotiation process, is it a representation or is it a term of the contract? The three rules we're going to consider try and help us get through the uncertainty that might occur in the real world. So the first rule we're going to deal with is the parole evidence rule. And it's kind of like, it's Latin. Parole is Latin for the oral evidence rule. And it's a very important one. It's why signed written agreements are so important, right? That you look at them, that you understand what you're agreeing to. It's why a lot of the colloquial advice about be very careful and putting things in writing and sign them is the way it is. It's not because it makes it more or less of a contract, but it makes more certain what's in the contract, which can be just as important as whether you've actually got a contract, right? So let's have a look at the parole evidence rule. So when the parties take time to formally draft a contract that expresses the whole of the agreement, then we have the parole evidence rule. This means the document, and really importantly, only the document is used to determine the terms. Other evidence that varies or contradicts that document is not admitted. So we can see from our authority, Mercantile Bank of Sydney and Taylor, where a contract is reduced to writing and appears to be entire, it's presumed that the writing contains all of the terms. Signed written document that's the whole of the agreement, that's the terms of the contract. There are some rare exceptions, as we've got documented in the slide, but they're very technical. You need to go away from thinking parole evidence rule. Signed written document that looks like the whole of the agreement. What's in the document is what the terms are. Anything else is not a term. It's very difficult to get in. So what that means is the parole evidence rule covers situations where there's a conflict or inconsistency between a complete contract and a verbal representation. You disregard what was said. In some rare circumstances, it is possible to show that the written document isn't the whole of the agreement. I won't go into those details, but that's very, very hard to do. And in fact, many contracts now overcome that problem with a term that says this is the whole of the agreement. So there's a whole of agreement clause. If a contract has this whole of agreement clause in it, the parole evidence rule says that there is no way you can get a verbal statement to be a term of the contract. Okay, so we've got trying to get verbal statements into a signed written contract. What about we've got a written contract and it had something in it that we weren't aware of? Right? Are we bound by what's in that document? The short answer is yes. And let's see Lestrange and Graucob, our case, to understand the court's thinking. So in Lestrange and Graucob, you had a cigarette machine manufacturer who sold a cigarette machine to a hotelier. And it ended up that the cigarette machine never worked. Okay. And as part of the contract, there was a disclaimer which said that the cigarette manufacturing company wouldn't be liable if it didn't work. Okay. So the hotelier is obviously upset. They bought a cigarette machine that doesn't work. They want to get out of the contract, but this disclaimer says they won't. And in fact, the disclaimer was in very small print, fine print, as the lawyers say. In fact, it was hard to read. The core conceptual legal principle that guides us here is if you've taken the time to reduce something to writing, you should have read it. It's presumed that you've read it, right? Even if it's very small. If you can't read it, you should ask the person what's it saying, etc., to ensure you know what it says. Because you've got to understand that the law's here trying to differentiate between two people, right? And both people might not be telling the truth. So if you could just say, well, I never knew what was in it, you could get out of contracts. And so therefore contracts become meaningless. So instead, the law takes the view that, look, no, if it's in writing, you should have read it. It's on you to read what's in the contract, okay? So let's look at the judgment to see that in the judge's words. There can be no dispute that where you've got a signed written agreement, it is immaterial whether you've read it or not. That's true. It's irrelevant that the plaintiff did not read or hear of the parts of the document which are in small print. And notice the judge is even recognising it was a little bit tricky here. I may add, however, that I wish the contract had been in a simpler and more usual form. It is unfortunate the important clause excluding conditions and warranties is in such small print. So he's kind of having a dig, but despite having a dig at how it was presented, you should read it. If something's in writing in the contract, it's in. It's a term. It's an obligation and right. But what about verbal statements that are made or other documents? Do they get included or not? We'll check that out in the next little video.